Thank you, Rick. Well, thank you to inviting me. I always appreciate the opportunity to come out and talk a little bit about this office because it is so new. There's no template in Canada for it, and so people don't always have a point of reference when it comes to what this office is about. I'm going to mention very briefly a little bit about our office, what we do, what we don't do, and speak a little bit on some of the kinds of questions or inquiries we're getting. But I'm going to spend most of my time talking about a couple of larger questions that I think are crucial to the property rights discussion. The creation of the Property Rights Advocate Office was a recommendation of the task force that was commissioned in late 2011 in the context of an intense public debate over property rights in Alberta. And as I mentioned, it is a unique office. It's the first of its kind in Canada. Although I have high hopes that we're going to see more in other provinces, much like we now have human rights commissions throughout the country, because I think property rights themselves are of such fundamental importance to a free and prosperous society. When this office was set up, the legislature gave us three basic tools to work with, three tasks. One is information on property rights, especially in relation to expropriation and compensable takings. The second tool is under Section 4 of our Act, and it sets out a complaint mechanism for landowners who are facing expropriation or a compensable taking. And if the owner feels that the rules weren't followed or if they dealt with unfairly, they can file a complaint with our office. We can look into it, issue a report, and then that report gets filed with either the court or the compensation board, whoever is looking at that matter when they set costs. And then the third tool is what I think in the long run will be of the greatest value of the current toolbox, and that's in the annual report that every year I have to file. And part of that annual report, I can make recommendations that I think are appropriate in relation to property rights. So that's really more of a law reform function. Now, we've already filed a 2012 annual report because in logic that can only happen in government, my office is open for exactly 7 business days in 2012. But the way the act was worded, I still had to file an annual report. So I did that. It was shy on activities, as you might guess, but I did set out some principles of property rights and make one recommendation that was really more of an estate planning tool for property rights for beneficiary deeds. So if you want to go onto our website, propertyrights.alberta.ca, you can have a look at that as well. In preparing for the 2013 report, which will be based on a full calendar year, we do maintain a series of issues files that are going to form the basis for the recommendations that go into the next report. So that's more of a law reform function. And as I said, I think amongst the current tools that are in the box, that is the one that's going to have the most relevance in the long run. We do not get involved in civil disputes between private parties. We do not, at the moment, have any authority in municipal land use issues. We're not a regulator, so we can't issue orders or impose penalties. Now, in terms of the calls we've been receiving, it's probably in some ways predictable. We deal with some fair process issues, Surface Rights Act issues, carbon capture and storage, and abandoned well sites. One area that was a bit of a surprise dealt with municipal government, and certainly in the early months, I think about a third of our calls dealt with municipal land use issues. And that's something that was a bit of a surprise because it wasn't a part of that intense debate that preceded this act. Now, I don't want to gloss over these specific problems that are faced by landowners, but I have come to think that a lot of the specific property rights issues are affected by a couple of larger questions that I had mentioned in the beginning of my remarks. And I think these larger questions have to be addressed if we're to properly deal with the particulars of the property rights specific problems in this province. And those two questions are cultural and philosophical in nature. The cultural question has to do with the gradual loss of a lot of our local institutions and services, the change of life in rural Alberta. And you see things like a loss of police service, local health board abolition, school board consolidation, centralized ambulance service, centralized 9/11 service. And the effect is that the accountability and control over what have been local issues and local services and local responsibilities are shifting to a central authority. So when it comes to property rights, the diminishing right a landowner has to say no in property rights issues, as well as being an immediate and specific important problem to that individual landowner, I think it also becomes something of a collective tipping point. It's just one more example of losing control over our way of life. So that's the cultural question. The second larger question is a philosophical one, and that's what we expect from government, what kind of government we want. And to put it in terms of a crude dichotomy, do we want small government or big government? Local government or a centralized government? Do we want limited government or a paternalistic and intrusive government? And I think this question is reflective of a trend where we have seen the workings of government become bigger, more centralized, and more involved in our lives. And ultimately, I'm coming to be convinced that a lot of the specific issues in the property rights debate are manifestations of this larger philosophical question. And you really see that in the Alberta Land Stewardship Act. As you know, that act establishes a framework for a series of 7 regionalized plans. And the draft South Saskatchewan plan has just been released not too long ago. Now, there are some people in government and others who support ALSA who do not understand the opposition to that act and to the regional plans, because a lot of the controls and the tools in ALSA are not much different from what municipal governments have been using for over 100 years. But based upon what I've been hearing, I've come to believe that a lot of the objections to ALSA are not really rooted in the concept of regional plans by themselves or regional controls. I think that the distinction for many people, the difference with ALSA, the objection to it, is that the responsibility and the authority for making and enforcing those restrictions are moving away from locally accountable municipal governments to the provincial cabinet. A cabinet that is seen, fairly or not, as centralized, remote, and perhaps unresponsive. So when people look at how ALSA implements the goals of the land use framework, when they see things like cabinet authority over the plans, of the power of the provincial government through the cabinet and the responsible minister to impose enforcement on municipalities, and of the diminishing and even non-existent right of local municipal governments, never mind landowners, to say no. These things are seen as signposts of central planning and of a trend of government being less local, less responsible, and less accountable. In essence, they hear the quacking, they see the waddle, and they think maybe it's a central planning duck. And I think therein lies the philosophical question and objection. And in that sense, property rights become as much about self-government through locally accountable bodies as they do about ownership rights per se. And I don't think throwing consultation into the process to justify and give validity to the authority that's assumed by cabinet does much if the process is seen as agenda-driven and the outcome is preordained. So, regardless of what you think of the Land Use Framework and of the Land Stewardship Act, even if you do support them, I think you need to at least acknowledge these perceptions, how some of the tools in ALSA might be seen as indicia of central planning or the tipping point of a cultural trend, and how that is something that brings to the discussion a visceral gut reaction based on philosophical principles and cultural experience. And I think that in turn contributes to the massive emotional element in the property rights discussion. There's an American professor, academic named Vincent Cavello, who does a lot of work in communications and crisis, and some of his work suggests that 90 to 95% of how messaging and communication is received or interpreted is based on emotion, not on fact or evidence. So I think that's why this emotional element and how it comes into it really has to be accounted for in the property rights debate. Now, I hope that consideration is reflected in some legislative reviews that are being planned. The Municipal Government Act is under review. That'll be a fairly lengthy, I'm guessing at least a 2-year process. Other acts, the Surface Rights Act and Expropriation Act, are, I'm told, going to be reviewed, although the time frame for that seems to be a moving target. I first heard about it when I was appointed last December. Then there was some thought of June. Then the target went to this fall, and now we're looking at the new year. So we'll see what happens there, but I'm hopeful that some of these things can be addressed in that review process. Now, I often close my remarks at these events with a bit of a story, and so if you've heard me speak before, forgive me. You probably know the story as well as I do, because I usually end with it. And that has to do with the first home that I remember living in, west of Barons on the family farm in southern Alberta. And that house was 4 rooms, no running water, no indoor plumbing. It was serviced by an outhouse and a hand pump. And it was something that my daughters, who live in a house with 5 bedrooms, 4 bathrooms, all of them indoors, have no concept of what it would be like to live in. And the reason I make that, or mention that, and make that distinction is to point out and to emphasize that for the family who lives in a 4-room house with no plumbing, no running water, no conveniences, that house is just as important and just as valuable, just as sacred as my home with indoor plumbing and a lake view is to my daughters. Because ultimately, the value of land ownership doesn't have a lot to do with market calculations, and paying money does not always make a taking better. The sad fact is that for landowners, they will not always have the right to say no. But landowners should never lose the right to have their values honestly respected, and that respect comes about when the encroachments on those rights are for a very limited purpose in a process that is fair. And I think it really comes down to asking ourselves 3 questions. And these are questions that in our office we've put into an operational value statement that's also on our website. And these are 3 things that we consider whenever we review an issue. First, is a given encroachment on private property rights necessary, either for a legitimate public good or to balance the fair use of property rights by another owner? Secondly, what outcome will best support the fullest possible enjoyment of private property rights as an essential element for a free and prosperous society? And third, what outcome will best respect the cultural and philosophical values that give significance to land ownership in Alberta? Now, the purpose of this office is not to cause division. It's not to set off one group of Albertans against another. We're not trying to rile up farmers and ranchers against industry or the province as a whole. Because I think that property rights are of concern to all Albertans. It's not just a rural issue. And part of our job at the Property Rights Advocate Office will be to give public voice to property rights concerns and to look for ways to support and improve those rights for all Albertans when those rights are threatened, even by the public interest. So I thank you for your patience, and I guess we'll deal with questions later. Thank you.